This is part 2, Peekaboo, we see you. In this segment, I am going to walk you step by step into realizing for yourself just how flagrantly obvious judicial corruption and usurpation is in my case. However, the gist of what I'm saying is encompassed in what you see before you. This is a judicial complaint that I had filed in the 11th Circuit on the two ringleaders, of course, William H. Pryor Jr., Frank M. Hull, Charles R. Wilson, J. L. Edmondson, Stanley Marcus, Jeroboam Tito Flat, and Aldeberto Jordan, and as well as the United States District Court Judge Lacey A. Collier, United States District Court for the Northern District of Florida. These are the judges I've been talking to you guys about so far. Like I say, William H. Pryor and Frank M. Hull are the ringleader. Now, the first few pages we have of this complaint, as you see, it's confidential. It's an 11th Judicial Council, Judicial Circuit. And the first few pages of this complaint pretty much just do what it says, like background. You can read it for yourself by pausing the videos, or you can go to my Instagram later. I have all the pages uploaded. And just give me a little bit of time. And this is all background. All background. Show you every page. Page 3. It's all background. And you get to page 4. This will be my actual complaint. I'm going to come back to that once I show you guys the complete document. This is page 4. And this is page 5. And at the bottom, you see you have this name, Beverly B. Martin. Now, Beverly B. Martin was a circuit judge for the 11th Circuit. And in my opinion, she was the most honorable one that was up there. And in fact, I believe that she retired early because of her honor. I mean, that's a matter probably one day somebody can talk to her and you know, figure out why she retires so early. But from reading her dissenting opinions, and I'm pretty sure she was disgusted with what she had to resolve here, I already know why she retired. But anyway, let's get to these merits real quick. So this is my complaint. And like I say, it's the gist of what pretty much is going to be in Peekaboo. I'm going to read it from the top to you guys. In his complaint of judicial misconduct or disability, complainant states he has never been provided a first-tier direct appeal by this court. He never waived his right to the assistance of counsel in appeal numbers 08-13771 and 17-14707, and a structural error requiring reversal occurred in those appeals. He alleges the circuit subject judges in those appeals refused to comply with, have respect for, and or have not maintained a professional compass in the law with regard to Sixth Amendment assistance of counsel jurisprudence in violation of the Code of Conduct for United States judges. Complainant asserts a reasonable inquiry will show the circuit subject judges acted with an improper motive, willfully failed to perform the duties of their office, and covered up the violation of his constitutional rights. He contends the circuit subject judges have created an appearance that they worked together to cover up the violation of his constitutional right to counsel, and it raises questions in regards to what misconduct could have occurred in other cases. Yes, I said that. He states the circuit subject judges engaged in misconduct in connection with the granting of his attorney's motion to withdraw in appeal number 08-13771, which left him without the assistance of counsel, constituted structural error and required automatic reversal. He also takes issue with the judges Wilson, Edmondson, and Hull's September 20th order, the September 2020 order denying his motion to recall the mandate in appeal number 17-14707. Next, complainant alleges Judge Collier, now this is the big fish, Judge Collier violated the Code of Conduct for United States judges by deliberately refusing to comply with, have respect for, and maintain a professional competence in the rule of law. Complainant alleges Judge Collier engaged in a concerted effort to keep him wrongfully incarcerated by silencing him in the Pt.2-PEEKABOO proceedings and effectively suppressing facts and evidence. He asserts Judge Collier's legal premise in an order denying a motion to reopen was foreclosed by precedent, and that he deliberately abused his discretion and issued orders with no substantive explanation. In a footnote, complainant states that a certain order will be appealed, but that it is likely the appeal will be intercepted by Judge William Pryor or a circuit judge who is not one of the subject judges. Complainant alleges that Judge Collier and his enablers on this court are refusing to comply with and be faithful to the law for the sole purpose of suppressing the fact that he was wrongfully convicted and is being falsely imprisoned. He also alleges the subject judge covered up that he was found not guilty of the controlled buys described in the indictment, which were the sole factual predicates of probable cause to have issued a search warrant that is dispositive to the indictment in his criminal case. Complainant contends the subject judge's honesty, integrity, impartiality, temperament, and fitness to serve as judges have been impaired. He also takes issue with the actions of individuals other than the subject judges, and he attached this court's September 2019 opinion in appeal number 1714707 to his complaint. Therein, pretty much the Honorable Judge Beverly Martin, bless her for putting my contentions out into the open, into a legal document. This document can be accessed, I'm pretty sure, on the 11th Circuit website. As long as you have these judicial complaint numbers, you should be able to get them. And it's as you see what it is, you can check it out for yourselves. All right, so now I'm going to go ahead and get into the meat and potatoes behind what you guys just read here, what I just read to you. So after you get convicted and sentenced in federal court, your first opportunity to correct any errors that you may feel that have occurred in the trial or proceedings that you had will be what is called a direct appeal. So in the direct appeal process, the appellant files a brief, the government files a brief, and then the court comes back with their opinion. This is how the opinion looks when delivered straight from the court. This is how it looks on LexisNexis. And if you notice right here, you see what it says, Antonio Uakil with my register number 068999017, appellant pro se. Remember what I told you, what I read to you guys earlier in the complaint? Right here. He never waived his right to the assistance of counsel in appeal number 0813771, and a structural error requiring reversal occurred in those appeals. Well, this right here in of itself substantiates that this is a structural error. This entire appeal is null and void. We'll get to that in a little bit, though. All right, so the importance of these direct appeals is they set a standard in all your proceedings, criminal and civil proceedings thereafter, and it's called the law of the case. It's called the law of the case. And what the law of case is pretty much, let's read right here. So, under the law of the case doctrine, the resolution of an issue decided at one stage of a case is binding at later stages of the same case. Under the law of the case doctrine, both the district court and court of appeals generally are bound by findings of fact and conclusions of law made by the court of appeals. But this is important to understand right here, this last part that I highlighted. The doctrine generally operates to preclude a re-examination of issues decided upon appeal. Okay, so now hear me out here. If an appeal court comes and says, for instance, hey, you conducted these control buys, you did these surveillance, we're going to affirm the denial of your Fourth Amendment based upon these things that were actually, acquitted, that I was acquitted of. But being that they spoke upon them like they were true, they would utilize the doctrine to preclude a re-examination of those issues. So whatever they say is just is what it is. Now it becomes a fact, even though it's I guess it's what alternative facts was that Kellyanne Conway, and so that's pretty much what happened in this appeal that I'm about to show you right now. Not only did the appeal court create a fictional and false law of the case to sustain my incarceration by saying what they said in the appeal here on this side, right there, talking about these controlled buys, all those things. All this stuff I was acquitted of. You guys saw that in part 1. Back over here on this side right here, you see how he talks about all these control buys and all this, all that stuff. Not only does that create a fictional and false law of the case, But guess what? It also violates my U.S. Constitution 5th Amendment right to be free from double jeopardy. How? I'll show you how. Okay, so under the 5th Amendment, we have this thing that's called collateral estoppel. It's called /issue preclusion. And collateral estoppel means that when an issue of ultimate fact has once been determined by a valid and final judgment, that issue cannot be litigated between the same parties in any future lawsuit. This principle extends to prevent redetermination of evidentiary facts as well as ultimate facts. And in 2009, the Supreme Court in Yeager versus United States, the case that you see before you now, they actually reiterated two principles in law. And I'm going to show them to you here. See what it says down here? A jury's acquittals unquestionably terminate a defendant's jeopardy with respect to the issues finally decided in those counts. My situation, count 4, count 5, the issues decided in there were the controlled buys and the entire narrative in support of that allegation, the surveillance, etc., law enforcement testimony, all that. Another point that the Supreme Court re-emphasized in this Yeager case is over here. The double jeopardy clause precludes the government from relitigating any issue that was necessarily decided by a jury's acquittal in a prior trial. From relitigating any issue that was necessarily decided by a jury's acquittal in a prior trial. Well, what made the United States and these judges violate the double jeopardy clause? Because that's exactly what they did in my direct appeal, was relitigate issues that the jury explicitly found me not guilty of, creating a fictional law of the case to sustain my incarceration, i.e. holding me judicial hostage, essentially. And apparently the 11th Circuit Court of Appeals has no respect for jury acquittals. However, the Supreme Court recently, in a case called McElrath versus Georgia, came out in 2024, they reemphasized to these lower courts and these type of judges that you see before you here, an acquittal, even one based on egregious legal or factual error, is absolutely conclusive. If the double jeopardy clause means anything, it means that the government, having failed to persuade one fact finder, is constitutionally prohibited from attempting a second bite at the apple. And double jeopardy issue preclusion, i.e. collateral estoppel, is constitutionally no different. A jury's verdict of acquittal represents the community's collective judgment regarding all the evidence and arguments presented to it. So, clearly these judges and these U.S. attorneys involved in my case, they have no respect for the acquittals. They have no respect for collateral estoppel. They have no respect for issue preclusion, whatever you want to call it, under any amendment, 5th, 4th, whatever. They don't care. They don't care about the law. Because if they cared about the law, they would know and correct the fact that by utilizing these facts in my direct appeal, facts that were already established against the government, the 11th Circuit Court of Appeals has denied me of my constitutional guarantee against double jeopardy, protected by the doctrine of collateral estoppel. In addition, by utilizing these facts, as a matter of fact, let me just pull the facts that they're using. By utilizing these words in my appeal, facts and issues for which the jury finally decided in acquitting me of counts 4 and 5, namely discussing these controlled buys as if they actually occurred in this case, the 11th Circuit Court of Appeals has usurped my jury right and completely removed the jury from standing in between me and the potentially, which I say really is arbitrary and abusive government from the United States, Northern District of Florida. Also, by utilizing issues and facts for which unquestionably were terminated by the jury's acquittals of counts 4 and 5, the 11th Circuit has not only created, but also sustained my incarceration for almost 2 decades based upon an untruthful and misleading law of the case. They were not allowed to say these words at all in their opinion in 2009. At all, y'all. As a matter of fact, they weren't allowed to say any of this stuff here. They weren't allowed to portray like count 4 and count 5 were at issue in this appeal because I was acquitted of them. Down here, they weren't allowed to talk about any of this stuff here. Page after page in this appeal. Page after page. Page after page. And I can keep going. I can keep going. I can keep going, y'all. They weren't allowed to talk. They weren't allowed to talk about any of this stuff, but to say, "Hey, Mr. Akil was acquitted of it. It's over with. The case is over. Vacate his convictions, grant him a certificate of innocence, and let him go home." And as a matter of fact, I want to show you how crafty and how slick these judges are in this appeal. You see this paragraph right here? Let me show you something. Okay, so now this is supposed to be a rendition of a trash pool that was discussed in a probable cause affidavit for a search of my house. And you see they go on with everything here. But when they get down here to where it says marijuana, loose tobacco, which was purposely removed from a blunt cigar, you see those three little dots? Period. Loose marijuana, which field tested with presumptive positive results, etc., etc. Those three little dots, they took something out right there. Let me show you guys what they took out. This is the actual trash pool. The words that they took out are right here. Your affiant knows that individuals who smoke marijuana routinely hollow out cigars to replace the tobacco with marijuana. So when you remove that sentence from here, which brings all this into the sphere of marijuana users, not distribution, you're trying to create a false artificial appearance, and deliberately so. What reason did this appeal court have to take that language out? What reason? You guys know why. Yeah, they also don't care about the law at all because, as I told you previously, and is in my judicial complaint, this direct appeal, their law of the case, was a structural error. Mando automatic reversal. Mando, nothing to talk about. The only thing you have to do, as the Supreme Court explained in Nita versus United States, I believe it was, is that you look and see if the person was represented by counsel. If he wasn't, as I was not, then you look to see if there's a waiver of counsel. It has to be a clear, intelligent waiver of counsel. And to show you that I'm correct in what I'm saying is, this happened to me in 2009. 10 years later, the 11th Circuit Court of Appeals came out with this case. United States versus Carlton Hammonds. Now, in this case, go down here, they wanted to decide a more fundamental question. See what it says here? Whether the defendant has waived his constitutional right to appellate counsel. Because we have a duty to establish the fact of waiver from the record, and because the record leaves us unconvinced that the defendant has clearly and unequivocally waived his right to counsel, we remand this case to the district court for determination of waiver in the first instance. Well, this is identical to my case from 2009, and this case actually helps expose the corruption in my case from 2009, because as I said, this is in 2019, and in 2019, in this very case, these judges, the 11th Circuit Court of Appeals, admit this. See what it says here? But this court has never delineated what is constitutionally required for knowing, voluntary, and intelligent waiver of appellate counsel. So, okay, in 2019, this court is admitting that they never had a strategy, a format, any type of way to conduct a knowing, voluntary, intelligent waiver of appellate counsel. Now, had they done the right thing in my case, they would have had that in 2009, but they didn't. They just deboed me out of my Sixth Amendment right to have counsel on direct appeal and swept it under the rug. That appeal number that I referenced to you guys, 08-13771, is full. It's a plethora of motions in there screaming from the top of my lungs. I did not have counsel. It's a structural error, automatic reversal. Please do the right thing. And they just don't do it over and over and over again. And they did the same thing to me in what I'm about to show you now, my 2255 proceeding. So in your regard, after you get denied on direct appeal, your next opportunity to try to obtain relief for the errors in your case is what is called 28 U.S.C. 2255. That's the federal equivalent of a habeas corpus motion. And I filed one of those in my case, obviously, and they railroaded me out of it by utilizing the artificial, fictional, fake law of the case and relying upon a procedural bar, which I'm going to show you here in a minute. Okay, so on 2255, I raised a few claims, several claims, but one being this right here that you see before you. It said Akel was denied his constitutional right to effective assistance of counsel when Randall Etheridge failed to properly litigate petitioner's Fourth Amendment claim. His failure to cite controlling precedent, incompetently putting forth falsities from an arrest affidavit and not the affidavit for the search warrant, coupled with his failure to rectify the mistake and present further evidence by filing an agreed-upon Franks hearing, were in violation of his Sixth Amendment rights. To which the government responded to my 2255 by, again, disregarding collateral estoppel and issue preclusion, damn my Fifth Amendment right, and relitigating this whole, re-arguing, discussing this whole thing about controlled buys and all this stuff, the search warrant and everything in my 2255. And they weren't allowed to do that. And they actually got the court to unlawfully procedurally bar my claim. Let's read this right here. Because the motion to suppress was thoroughly argued before the trial court and on appeal, the government argues that the defendant's challenge to counsel's performance in this respect is procedurally barred. He says the court agrees that two of the three arguments the defendant makes in his motion are procedurally barred. So basically what the government is saying is that because I challenged my Fourth Amendment claim on direct appeal, and the direct appeal court came through and saved the day for him and created the artificial appearance that these controlled buys occurred by saying that because the appeal court was kind enough to put this language in here depicting these controlled buys as if they actually occurred, that I am now procedurally barred from saying, hey, those controlled buys never occurred. You guys missed the jury verdict. And they literally been suppressing me from being heard on 2255 for that. Based upon that erroneous and absurd premise that they're doing to me, man, to keep me silent. That's why it's in my judicial complaint that you read. All this stuff is a violation of my Fifth Amendment. Everything. That's all a violation of double jeopardy. Every part of it. Disregards the jury verdict, everything. And then they use this to deny me the right to even be heard on 2255, getting me procedurally barred based upon this direct appeal. The fake, artificial, erroneous law of the case. Not only was the government's position clearly wrong and erroneous based upon that fake law of the case, but the 11th Circuit itself, in a case called Brown versus United States, actually instructively clarified the very error in procedural bar ruling that occurred in my case, in this case called Brown versus United States. And as you see, it would say, as an initial matter, we find it instructive to discuss the district court's conclusion that Brown is procedurally barred from raising this claim because he presented the claim on direct appeal. Typically, a prisoner is procedurally barred from relitigating an issue on collateral review that he already raised in his direct appeal. Where, however, facts essential to a claim are not in the appellate record, the general rule in favor of a procedural bar does not apply, and the issue may be raised on collateral review to permit further factual development. One example of a claim typically requiring further factual development through a 2255 proceeding is a claim based on ineffective assistance of counsel. Clearly, my 2255 raised was substantiated and based upon matters outside of the 2009 direct appeal record because it relies upon the affidavit of my attorney, Randall Etheridge, which was at docket 164-1, 5/17/2011. It's a little year and a half over my direct appeal. Also, this affidavit from my private investigator, William Anderson Dixon, which was also at docket 174-1, filed on 7/22/11. Now, this was also outside of the record. As well as this testimony that I obtained from my attorney at an evidentiary hearing on January 28, 2014. That right there. as well as from right here. You guys remember that from the first part, asking him why he didn't file the Frank's motion or dismissal of the indictment based upon the acquittals of the controlled buys. So clearly, my claim was substantiated based upon things that weren't in the 2009 record, and I should have been, afforded a merits review, but I never was. Because they don't want to hear the claim. They know it's a major claim and it has major consequences. However, my 2255 wasn't all bad for me, because despite the suppression and oppression given to me in the district court as well as the 11th Circuit, who denied me the right for a COA to appeal the denial of my 2255, also being Judge William Pryor and Frank M. Hull, I managed to, on my own, win my case in the Supreme Court of the United States, which you see before you now. I actually won on April 3rd, 2017, and it was in light of Mathis versus United States. And what that was supposed to have allowed me to do was go back to court for a full resentencing, because I was no longer what is called an armed career criminal, and that changes my criminal history score, basically subjecting me to a lower penalty range. However, Judge Lacey Collier, being so corrupt, found a slick way to get around it and simply issued an amended judgment sentencing me to the same 40-year sentence he previously imposed. What he did not anticipate is what comes after, what's going to be in this third video called No, 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 Not Again. However, before I wrap this up, I want to show you guys an order that issued June 8th, 2018. This order demonstrates to you exactly how they are suppressing me and keeping me boxed in based upon that erroneous and fake law of the case. You see right here, start from here. Additionally, as to Akel's claim that his counsel was ineffective in failing to raise a Fourth Amendment issue, the court concluded that the majority of Akel's arguments were procedurally barred because they sought to relitigate issues decided on direct appeal couched in terms of ineffective assistance. Now you see right there, that's absurd in of itself. The only things I ever argued is that there were no control buys. I got acquitted of it, not guilty. And they simply ignored it and covered up. Now, in this appeal, I had asked this court for summary reversal, and this is what they told me. See right here? It says Akel has filed a motion for summary reversal, arguing that the district court's denial of his ineffective assistance claim regarding the Fourth Amendment issues was erroneous. Summary disposition is appropriate where the position of one of the parties is clearly right as a matter of law, so that there can be no substantial question as to the outcome of the case. Akel argues that the district court ignored Kimmelman. That's a Supreme Court case called Kimmelman versus Morrison, in which the Supreme Court declined to extend the restriction on federal habeas review of Fourth Amendment claims to Sixth Amendment ineffective assistance of counsel claims. However, a movement is procedurally barred from raising a claim in a 2255 motion. Hold on 1 second, you guys. As a matter of fact, I'm going to read the summary reversal section again because I don't believe it came out correct. Here, Akel has filed a motion for summary reversal, arguing that the district court's denial of his ineffective assistance claim regarding the Fourth Amendment issues was erroneous. Summary disposition is appropriate where the position of one of the parties is clearly right as a matter of law, so that there can be no substantial question as to the outcome of the case. Akel argues that the district court ignored Kimmelman, in which the Supreme Court declined to extend the restriction on federal habeas review of Fourth Amendment claims to Sixth Amendment claims. Sixth Amendment ineffective assistance of counsel claims. However, a movement is procedurally barred from raising a claim in a 2255 motion that was decided adversely against him on direct appeal. Remember I told you guys about the law of the case? If it was decided adversely against you on direct appeal? Okay. Although a Sixth Amendment ineffective assistance of counsel claim is distinct from the underlying substantial issue, because this court found Akel's Fourth Amendment claims meritless, he cannot establish that he was prejudiced by counsel's failure to raise these claims. Accordingly, Akel's position is not clearly right as a matter of law, and his motion for summary reversal is denied. You see that? They just say my Fourth Amendment issue is meritless because they said that the surveillance of the controlled buys and the fact that I did control buys and all that warrants me being denied my Fourth Amendment rights. However, I got found not guilty of it. Issue preclusion, double jeopardy, Fifth Amendment mandates that this 11th Circuit Court of Appeals corrects this. They're holding me in prison like a judicial hostage.